Hi, I'm Shannen Trout and I'm a trainee solicitor at Floyd Zadkovich. Today I'm going to be talking about how international businesses could utilise pre-contractual representations in order to protect themselves during an economic crisis. This video is one of a series whereby myself and my colleagues at Floyd Zadkovich will aim to provide you guys with some interesting and useful information to help you through these difficult times.
Floyd Zadkovich, International Commercial Lawyers.
There are a lot of deals and contracts right now that won't be being entered into because of the difficult time that we're facing. However, there will be some people out there that will be entering into commercial negotiations, and it's important for them to understand from the outset exactly how to protect themselves. In this video, I'm going to be discussing pre-contractual representations and the case of Hadley and Baxendale in order to explain the possibilities available to parties entering into such negotiations during these challenging times. So, let's start with pre-contractual representations. What exactly are they? A pre-contractual representation is a statement given in fact or law which induces one party to enter into the contract prior to that contract being made. If it turns out that this representation was incorrect, then the wronged party might have the right to sue for misrepresentation. There are three different types of misrepresentation, namely innocent, negligent, and fraudulent, and it depends on what type of misrepresentation has occurred on what type of remedy is available to the wronged party. Generally, misrepresentation allows the party to either rescind the contract or claim damages for the losses suffered because of entering into the contract. The effect of the remedy should essentially put the parties back in the position that they would have been in if the contract had never existed. Sometimes parties intend for these representations to have contractual force and not merely be used as a negotiating tool prior to entering into the contract. This, however, will ultimately depend on the parties' intentions. It is recommended that if a condition or something that is discussed prior to entering into a contract is so important to you that you make it an express term of your contract in order to avoid any confusion. Alternatively, if there are pre-contractual communications that you don't intend to be part of your contract, you might want to label them subject to contract in order to avoid such doubt. It's important to keep pre-contractual representations in mind as a means of protection during these challenging times. By utilising them, it is possible to set up a situation where you can get certain assurances as to financial standing of a counterparty or of the contract that you're about to enter into. As explained, if a party relies on affirmations as to financial standing to enter into a contract, and these affirmations turn out to be incorrect, then you might be able to rescind your contract or claim damages for the losses that you suffer. These pre-contractual representations provide parties with a remedy before resorting to suing for breach of contract. To conclude on this point, although relying on a pre-contractual representation may seem like a simple solution to the problems that could arise in these circumstances, they provide an alternative means of protection that international businesses should be considering in the coming months. Now we can move on to consider the case of Hadley and Baxendale and its usefulness in these situations. First off, let's consider the facts of the case. In this case, the plaintiff operated a mill. The crankshaft in the mill had broken down, rendering it completely inoperable, and so the plaintiff acquired the defendant's services to deliver the shaft to the engineer's warehouse, where it would be used as a model to make a new crankshaft. The plaintiff had informed the defendant that this needed to be done immediately. However, and quite importantly, in this case, the defendant was completely unaware at the time that the mill would be unworkable without a new shaft. The shaft was delivered 7 days later, and the plaintiff claimed that the defendant's negligence had caused the mill to be inoperable for an extra 5 days than planned. On this basis, they claimed damages for loss of profit. However, the defendant argued that the damages sought were far too remote to be claimed successfully. The important part of this case comes from the judgment. In this case, it was said that for damages to be available for breach of contract, they should be those which might fairly and reasonably be considered as arising naturally from the breach of contract, or they should be such damages as may reasonably be supposed to have been in the contemplation of both parties at the time the contract was made. If the contract arose under special circumstances, it was important for these to be communicated. If done, they could be considered to fall within the rules laid out in the case. However, if those special circumstances were unknown to the parties, then the party alleged of the breach could only be supposed to have contemplated the damages as arising naturally from a breach of that kind. There is a lot of debate about what reasonable contemplation is, but the key takeaway from this case is that if you want to be able to recover damages, that the other party should be made fully aware of your special circumstances. If prior to entering into the contract, you are aware that there are consequential losses that you might suffer because you have, for example, entered into a back-to-back contract that is back-to-back with this deal, then it could be a beneficial idea for you to share such information on the basis that it will make the other parties to the contract aware of your special circumstance, thus making your losses recoverable under the Hadley and Baxendale test. Commercial sensitivities should of course be considered, and we're not suggesting that you give away all of your trade secrets. However, divulging certain information could protect you in recovering such losses that would not ordinarily arise from the breach at hand. The Hadley and Baxendale decision is an important one for English contract law, and it could provide international businesses with something to consider when entering into commercial negotiations during such difficult times. You should be asking yourself, when entering into pre-contractual discussions, what losses could I suffer if there is a breach of contract, and should I be making parties aware of this in order to be able to recover the losses? It is much more likely that there will be successful recovery if this is the way you approach pre-contractual negotiations. To conclude on both pre-contractual representations and the Hadley and Baxendale remoteness test, I would like to round up with 3 key takeaway points that could help you and your business, not only during times of economic crisis, but whenever entering into contracts in the future. My first key takeaway is to always consider the possibility of a pre-contractual statement as a means of protection and an alternative cause of action if a party turns out to have made a misrepresentation prior to entering into the contract. The second takeaway is that when entering into contracts, if a representation is made pre-contract and is important to you, you should push to have this included as an express term of your contract. The third and final takeaway, and the key learning point, is to contemplate whether your situation is special or different to those that would normally arise in your business. Do you have any special losses that might arise if a breach is to occur, and should the other party be made aware of this? That's all from me today. Thank you for watching. I hope that you found this helpful, or at least interesting to watch whilst being stuck indoors. If you have any questions, please don't hesitate to ask myself or anyone at the Floyd Zadkovich team, where we'd be happy to help you with all of your queries. Thank you for watching again, and stay safe.